Mrs. Vergeer, you're still under oath.
Thank you, my lady.
Thank you. Yes, Mr. Mayor.
Let's go, please. Madam, I think I don't know if I understand it correctly. Are you still employed by the Department of Social Welfare?
That is correct, my lady.
And as part of your employment, you have permission to do private assessments and private probation officer's report, and these are one of them. Or am I wrong?
That is correct, my lady.
So I'm correct. Good.
As I've explained to the Honourable Court, it is by obtaining permission, and that is granted on a yearly basis.
In the normal scope of probation officer report, if there would have been a request through the court, somebody in this region would have been appointed that's still with this department and would have done it in the normal scope of his or her duties.
That is if the court required such a report, my lady.
But that would have been done in the normal scope of their duties as an official from the Department of Welfare.
Of social development,
social
that is correct, my lady.
Good. Now, as an official within the department, certainly you could approach officials in other departments like correctional services to get real facts about conditions.
I do not understand the question. I'm not sure what...
You're an official of social welfare. You want to know what's going on in a prison and what facilities they have. You can officially request that information from another department because we're all in the government service.
That is in fact so, my lady.
Did you for this case?
My lady, I did in fact. I spoke to the official in Pretoria as indicated in my report, and I've also got the latest report on the circumstances in the prisons, so additional information can be obtained.
Let us just deal with it. The idea I get is, from reading your report, you phoned the Pretoria prison and spoke to a welfare officer.
That is correct.
So officially, I mean, writing a letter saying, I am here, I want you to respond and give me the detail. You never thought about doing that?
My lady, not in this particular case, no.
Have you done it in other cases?
I have done it, my lady, and they are not allowed to give detail through which may or might expose the department to a certain extent. So information and their names they are not allowed to make available.
Can I ask you, I've asked you now a question. Have you officially in writing requested information? You said yes. Am I right? In other matters?
I just wanted to add in other matters that is so, my lady.
And did you not get a response?
I couldn't get a response, my lady, because I was told that they cannot be exposed for purpose of the court case.
Did you? But I mean, you can ask the department at any level. There must be somebody in another department that can give you that information. Because they're here at court today, they would give it. Why would they not give it to you?
I don't maybe have the authority to just summon them to come to court, my lady, but I have approached them and I have asked assistance in the past.
But let us see what you used for this case. Remember I asked you if you would indicate where you got the information from, and you said from the internet, and you referred me to a web page. Am I right?
That is correct, my lady.
Yesterday after court you identified the web page. Is that correct?
That is correct, my lady.
Now, the web page that you identified, that deals with a speech made by the General Secretary of Pop Crew, Abby Witbooi.
Can you identify the web page for me, please?
My lady, yes. It's www.csvr.org.za/wits.
Pardon?
/ my lady.
Yes.
Wits. / again. CONF conference PAPS. CONF PAPS / Witboy.
Vit.
Witboy.
Vit.
Wit BOOI. Witboy.
Yes. Thank you.
.hdm. Now, that particular webpage deal with a speech by Mr. Abby Witboy, who was at the time the General Secretary of POPCRU.
That is correct, my lady.
So, not a senior official in the Department of Correctional Services, but the General Secretary of the Union.
I take note, my lady.
You see, take note. Okay. And when was that? When did he make the speech? Do you know?
It was at a conference 7 to 8 February 2005, my lady.
2005, it's 9 years ago.
6 years ago, my lady.
It's
9 years ago.
Yes.
I'm sorry. Apologies. Thank you, my lady.
That's 9 years ago. A speech made by the General Secretary of POPCRU, and that is what you put in your report. So this webpage reference, have you used it before in other reports?
I have, my lady.
The stats you refer to the court deals with stats of, you say at page 38, the 237 operational prisons in South Africa currently provide accommodation to 114,559 prisoners.
Hold on, Mr. Nile, you're rushing. You are now with Exhibit WEEE,
Indeed, my lady.
page 38.
Indeed, my lady.
Okay. Yes.
And what stats are those? If you say currently, is it today? Or what are you trying to tell the court?
It was during the time of the completion of this report, my lady.
And you got that from where? So that's October 2014.
No, not my report. It was obtained from an extraction from this article, my lady.
Oh, for Judge Chikiso, that was in 2008.
That's correct, my lady.
Okay, so the stats that you give this court is 2008 and 2005. Anything more recent than that?
Now, only the one by Judge Chikiso, which was also in my report, my lady.
Chikiso, yeah, that's 2008.
That's correct, my
Okay.
lady.
But I mean, is there anything more recent than 2008 as far as statistics are concerned in your report?
No, my lady, except that the figures have increased, in fact, and but I did not quote the recent figures.
And conditions have improved, or don't you know?
Not as far as the latest report, my lady.
Not as far as numbers are concerned, conditions in prisons, or don't you know, since 2005?
Not as far as the report from the Judicial Inspectorate to 2011-2012, my lady.
We will deal with that. Can I just also ask you, the General Secretary of POPCRU, you used his speech and you extracted the paragraphs at page 39.
That's correct, my lady.
The main concern of Mr. Witboy at that conference was what? What did he address, in fact?
The key factors, my lady, were the crisis in the prison system.
Because of what? What was his main?
There were a few or various factors mentioned, my lady, which was incompetence, overcrowding, and the shortage of staff and understaff.
Yeah, he said his main concern, and the court will ever read it, the unwillingness or inability of the department to appoint entry-level staff like a union person would do. That was his main concern. Have you read it again?
I'm just looking at the article, my lady. Some of the factors here mentioned as well was what I have said.
But that was in 2005.
That is correct, my
Now,
lady.
In all your years that you've been doing this kind of work, certainly you know the Act, Correctional Services Act.
No, my lady, I'm not a specialist on the field. I'm informed of the acts, but I don't know the acts.
But at least let's see what you know. You know that a sentenced prisoner can, in writing, apply for a single cell.
My lady, I cannot comment on that. I do not know the act.
You see, what I find very interesting is that you would want to come to court and deal with conditions in the prisons, but you don't know how prisons are run and what the Act dictates. How can you do that?
My lady, I can give an opinion to the Honourable Court concerning experience that I've obtained, knowledge gained, and information obtained, but I cannot deal on an act which is not part of my framework.
You know, the Act, that the Section 31A would say that a person can apply. Section 31C, in summary, indicates that upon admission, a medical officer or a doctor can also dictate that a person be kept in a single cell because of any medical condition or vulnerability.
I take note thereof, my lady.
There's also an assessment in terms of Section 38 of every prisoner that would arrive to ascertain the vulnerability of the prisoner and where best he could be placed. Do you know that?
I take note thereof, my lady.
And that there are regulations that would indicate that no medical devices may be removed from any prisoner without a directive from a doctor or a medical officer.
I take note thereof, my lady.
You see, I know that you're taking note, and I'm just worried that we come to court as probation officers in private business and complain about the conditions in prisons but don't know this. That's what's bothering me. Why don't you know this?
My lady, I'm not supposed to know the acts of each and every department. It is not within my framework or that I am supposed to know.
But certainly, madam, you shouldn't know anything about water affairs, I agree. But you should know everything about prisons because you commenting and giving opinions on prisons, and you don't.
I can give an opinion, my lady, on experience and what has happened to me and on what I read, but I cannot give an opinion on the act.
Okay, do you know anything about the White Paper on Correctional Services 2005?
No, my lady.
So then you wouldn't know that there's a specific section in that White Paper dealing with prisoners with disabilities. And how
No, my lady.
You also don't know that the Department of Correctional Services has and follow a policy on disabilities. You don't know that they have a policy on it.
No, I take note, my lady.
You've not, in preparation for this, by telling the court that your opinion is that this accused cannot be incarcerated for certain reasons or imprisoned, you never asked the department if they have a policy, how they treat disabled people. You never thought of just asking.
I have consulted with them. That's in my report. I've already referred to that, my lady.
You've consulted with a person on a phone, that's all.
That is correct, my lady.
You don't know the person, you've not seen the person at all.
That is correct, my lady.
You've made one phone call, a person answered, the person identified themselves, and you had an interview.
That's correct, my lady.
Did you verify anything about that interview?
Yes, my lady, what I've got in my report.
No. Did you verify if the person was exactly in the position that she said she was?
No, my lady, as she did not want to be exposed for purpose of the court.
So what we have, we come to the High Court and we say, I picked up a phone, I phoned the prisons, I spoke to somebody, and this is what the somebody said. That's all you can say.
That's correct, my lady.
You can't say that. You can't tell this court that that is what the position of that person within the correctional facility is. You can't.
No, my lady. Except that I phoned and asked to speak to the social work department, that the lady identified herself but wished not to be exposed for purpose of the court.
I see. Then, the witness I intend to call will indicate to you that there is not even the slightest possibility that the accused's prosthesis will be taken away from him. There are people with wheelchairs in prison. Do you know that?
I know that, my lady.
Their wheelchairs are not taken away. Or do you disagree?
I have not asked him, but not that I know of, my lady.
Do you agree that a person in a wheelchair is more vulnerable than a person on prosthetic legs?
I cannot dispute disability's vulnerability, my lady.
Now, if a sentenced prisoner or any person in a facility would have a complaint, what would he be able to do about complaints? Do you know?
No, my lady.
You see, I find that so irresponsible, man, that you would come to court, venture an opinion on the Department of Correctional Services, but don't know anything about the department. And you employed by another state department.
I can only give what I could have obtained, my lady, but since we have an expert that's going to testify, those facts will be placed before the court.
You see, madam, we go to court as probation officers to courts daily. The preparation or lack of preparation, that is what's bothering me, and that's why I'm testing you. Why would you not go and find this out?
My lady, I cannot find out everything from a specific department, because what is important for one person on one aspect might not be for another person, and it may also vary from prison to prison, and it could differ from day to day. So I do not have the policies or the laws concerning the prison environment.
You know, madam, I read your report. You have a view of what happens in a prison. You testify as a professional, but you have not verified it. And that is worrying. Why don't you verify it before you give evidence in a high court?
My lady, that would depend on what I need to verify, because that would also differ from court to court. I can speak from a lot of experience, and I can speak from a lot of what I have obtained through my years of experience, but I cannot know what would be required to test concerning a specific matter.
Let us make it much more practical and deal with the local prison in Pretoria, Pretoria Central Prison. You've said you've been there.
I've been there for visits, my lady.
Visits would mean you would visit a client in the facility that's made available, not in the prison, or am I wrong?
That is correct, my lady.
Okay. Do you know that the Pretoria Central Prison has, and I used to refer to it as hospital section. I've been corrected this morning. It's health care facilities. Health facilities. That's the better word for this. That Pretoria Central has a health facility.
Yes, my lady.
That people could be kept in a health facility.
That is correct, sir, my lady.
That there are single cells at the health facility.
I've been informed of the single cells in the health facility,
that they have
my lady.
baths and showers.
I'm not aware of the baths, my lady. I'm aware of the showers.
You see, you go further. You say, there are no baths. That's what you did.
I did say that, my lady.
Why would you do that if I tell you that a mere inquiry would have indicated to you that there are baths?
I did inquire, my lady. If I was not informed thereof, I cannot assist the court on
Okay.
that.
Can I just ask you then? So the lady that you spoke to, that we don't know who she was, lied to you.
No, I never said she lied to me, my lady.
She failed to give you things, information.
Not all of the information or the proper information. That is correct, my
On
lady.
what did you base your factual statement? There are no baths.
On the visit to the prison where I saw no baths, my lady, and that was the only one that I could have access to.
Madam, the irresponsibility to put in a report. I visited a prison 2 years ago. Only a single prison, Krugersdorp. Now I make a statement about prisons in this country by saying there are no baths. How can you do that? How do you do that?
I take note, my lady,
No, take note of what?
of the fact that there is a bath in Pretoria Central in the
But I'm
medical
asking you,
facility.
how can you do that? How can you put in a report that it's a fact and you haven't verified it? That's what I want you to
If I was not informed thereof, my lady, I cannot put it in for the Honourable Court.
Why would you not say, I don't know if they have baths there? Why do you put it as a fact?
Because I was informed, my lady, that they do not have facilities
Who
for
told you that?
the specific social worker that I spoke to could not assist me on confirming that they would be able to accommodate the accused.
No, you see, again, madam, it's a long answer. We're not answering the question. So I'm going to ask it again. Who informed you that there are no baths? Just answer that question, that one. Who informed you of that?
The person that I spoke with, that's a social worker, my lady.
So you asked her the question,
That's correct,
and
my
she
lady.
lied to you.
No, I don't say that she lied
What
to
did,
me,
but
my
but
lady.
she told you there are no baths.
I did not specifically ask her, are there baths? I asked her if there were facilities for a person with the accuser's disability.
Madam, this record will be typed. 2 questions ago, I asked you, who did you ask if there are any baths? And you said, the person I spoke to.
Not,
Why would you do that?
not specifically a bath, my
I
lady.
asked you specifically a bath, madam.
Then I understood the question incorrect, my lady.
Okay, let's start again. Did you ask any person if there are baths in the prison?
No, my lady.
Why did you then put as a fact that there are no baths in prison?
Because I was informed of the fact that there are no baths available, my lady.
No, I don't understand that. I really don't. If you never ask a person, oh, you know what? Perhaps I forgot to ask one more question. Were you ever informed by anybody that there are no baths in prison? Did anybody that volunteered or whatever, did any person, and listen to the question, ever inform you that there are no baths in prison?
Yes, my lady.
Who was that?
My lady, again, not specifically pertain to the question of this lady, but all the interviews which I have conducted, I have never been informed in the 28 years that there are a bath available in the prison.
No, you see, again, you say, I've never been informed. I ask you, if somebody told you that there are no baths, answer this question. Madam, we went through this yesterday. You deliberately not answering the questions.
I take note, my lady.
So, answer the question. Listen to it, please, and answer it. Has anybody ever tell you? Has anybody ever told you that there are no baths in prison?
I'm not sure what I have to answer to the Honourable Court.
Yes or no?
because- Yes, my lady.
Who? Who told you? Madam, there are no baths in prison. I want to have that person who told you that.
I cannot give the person's name specifically, my lady.
Who-
Concerning the facilities in the prison, I ask with each and every interview, and I have never been informed of the fact that there is a bath available.
You see, madam, you deliberately misunderstanding. And I'm going to do it again. Listen to the question, please. Has anybody ever told you there are no baths in prison? Just that. Answer that question. Not, nobody's ever told me that off a bath, so therefore I make an inference. The question is just this. Has anybody ever told you There are no bars in prison.
Yes, my lady. I have to say yes.
Who?
Again, my lady, concerning the interviews that I have conducted with people that are in prison, they have confirmed that there are no bars available.
In their specific section.
In a specific section, it might be, my lady.
In a specific section, in a specific facility. And then you elevated that to prisons in South Africa. Am I right?
I said that there are no bars available. That is correct, my lady.
But you only spoke to people in certain sections. They would say, in our section, there's no bars.
That is correct, my lady.
No, madam. Let us just deal with complaints. So, if a prisoner, or if this accused is sentenced to imprisonment and he has complaints, do you think there's avenues for him to make it known what his complaints would be?
I know there are avenues, but I don't know the specific avenues, my lady.
Now, you're a professional person, you're giving evidence in the High Court. What do you think? How would that happen? Because you've recommended things before. How do you think they would complain?
I'm not sure if I understand the question correct, my lady.
You say you're sure there are avenues.
Again, my lady, I've been informed of avenues that people can make use of, but I don't know the specific procedures once you are a detained prisoner to follow.
You see, madam, my biggest concern is the following. You're giving evidence to this court. You're venturing an opinion about prisons. Now, luckily we have people from Correctional Service here. But if we did not, then the court would have asked you this following question. If the accused had a complaint about his treatment, what would he do? What would your answer have been?
I would not know what he would do, my lady.
So you would tell the court, if they take away his prosthetic legs and he wants to complain, I don't know what he could do.
I would not know what is his first step, my lady.
Any step?
No, my lady.
Oh, sure. Standing where you're standing, you can't think of anything you could do.
No, my lady.
You've not read in the papers how inmates, prisoners would take the Department of Correctional Services to court to deal with their treatment, to deal with parole, to deal with lots of things. You've not read that.
I've been informed of that, my lady.
So, but that never crossed your mind that is a possibility.
That is a possibility, my lady.
Well, madam, there are various things they could do. Section 21 of the Act indicates that daily, madam, if I took, madam, I apologize, my lady. If I deal with the Act, it's the Correctional Services Act. And regulations, it's Act 111 of 1998. In every facility, and that's a prison, on a daily basis, inmates must be given the opportunity of making complaints and requests. On a daily basis, somebody must take complaints and requests from prisoners. You can't deny that? That the Act
No,
says
my
that?
lady.
Read with the regulations, those complaints must be dealt with at the longest within 7 days. You don't know about that?
I take note, my lady.
Also, in terms of Section 93 of this Act, makes provision for independent correctional center visitors, independent people that would have access on behalf of the inspecting judge, free access to prisons, to go in and take complaints from people. Do you know about that?
I've been informed thereof, my lady.
By? So before you got to court, you've been informed of that?
I just know that there are people that go independently into the prisons to investigate the circumstances.
And to take complaints.
That's correct, my lady.
Okay, so at least you know about that one. And then in terms of Section 99 of the Act, and I summarize, judges, magistrates and various people have access to prisons, visit prisons and take complaints and investigate the conditions. Even parliamentarians. Am I right?
I take note thereof, my lady.
And you didn't know about that?
I did not know that judges or magistrates and other people go in and make notes. So I take note thereof, my lady.
Good. Now, let us deal. Remember when we started this, we said we deal with Pretoria Central Prison. Now, the Pretoria Central Prison, which this court falls within the jurisdiction of Pretoria Central Prison. In their health section, they indeed have single cells, bath and showers. You cannot deny that.
No, I take note thereof, my lady.
Okay. Now, madam, I'm going to deal with portions of your report just here and there, just fleetingly. At page 13, you indicate that the deceased family members, they wanted to remain neutral.
Is it 1 3 you're
No,
talking about?
but I read it wrongly. May I withdraw that question? You indicated at page 14 that the purpose of sentence as far as deterrence and prevention are concerned, you took into account and should be taken into account by a court.
That's correct, my lady.
Now, you indicate nicely in the second paragraph, to deter other would-be offenders from committing offences. That is what a court should do with a sentence.
That is correct, my lady.
In this,
Where are you? I'm getting
page
lost.
14 of
1
the
4.
report, D.
Yes, what paragraph?
Second paragraph, my lady?
Deterrence and prevention.
Yes, my lady.
Thank you.
The first paragraph, sentence must not only aim at preventing the particular accused to reoffend, but also deter other would-be offenders from committing offences. What would one deter other people from as far as this case is concerned?
Committing a similar type of an offence, my lady.
What type of offence?
That could be, as within the case of the accused, the negligent firing of a firearm and the culpable homicide.
Yeah, but is it only culpable homicide, or what would one more deal with the facts of the particular matter, what you would want other people not to do? Or is it just the mere fact that it's culpable homicide?
I presume it would be the facts as well, my lady.
Okay, what facts did you take into account that the court would want to deter other people from doing?
I think one should start with the possession of a firearm. Or I'm not sure if that is one of the...
Let's just deal with the culpable homicide matter.
Maybe if the advocate can ask me questions, my lady, because I'm not sure.
I've asked you a question. What did you take into account as far as the facts are concerned that the court would want to deter others from doing? That's my question.
The sentences should be of such a nature, my lady, that people would be deterred from, I would say, not only getting involved, but thinking before they would commit an offence.
What in this particular matter did you take into account that people should be deterred from doing?
I'd have to answer it from my own framework, my lady, which would be coming from where I'm coming, as I'm not a legal expert. So it would be concerning the fact that he used a firearm, and that people that are negligent with or concerning the use of a firearm, possession of ammunition, should be deterred to have a firearm, or there should be rules or regulations implemented to prevent them from having a firearm.
No, Madam, you know, it makes this. How can that be what you had in mind? The sentence should deter people from owning legal firearms.
My lady, there are so many aspects. One has to look at the totality of the person. You have to look at therapy. You have to look at putting certain things in place so that the person will not or rehabilitate. So I'm not actually sure exactly what I should answer on.
You see, that's why I'm asking the question. It's your report. You put things in this report, and I want you to tell the court what you took into account and what you want the court to deter others from.
That's not a problem, my lady. One has to look at factors which I've incorporated, for instance, on, but that's not the only factors, page 18, where I said one would look at the history of such a person, and then one would implement the sentence option. One would look at the fact whether they are first offenders or not. One would look at age-related factors. One would look at whether this person has the ability to change. One would look at his personal circumstances. One would look at remorse. One would look at the fact that he was detained for a short period of time. One would also look at the increase and the escalation of crime in South Africa, and especially violent crimes and crimes towards women and children in general. One should also look at the totality of the crime and the people affected by it, and the seriousness of the offence. And those are just factors from my perspective or point of view, my lady.
Madam, you haven't answered my question. My question deals with a single aspect of everything you mentioned. You said, also to deter other would-be offenders from committing offences. What in this particular matter must the court with a sentence deter others from doing?
I'm not sure how to answer that question, my lady, because I thought if the court imposes a sentence which is just and fair, that it would be also serving as a deterrence for other people.
You see, madam, I asked the question just to see how much thought went into your report, because I get an idea that we're dealing with a pro forma, and that you just have a pro forma of things that you don't apply. Because if you applied the deterrent factor and what you said there, you would be able to tell the court what.
Again, I cannot help my lady if I'm not, I'm at lost here. I'm not sure exactly what.
Are you using a pro forma that your reports would all look the same, that you change here and there, you tweak your reports here and there? Because I have from your reports. You have one big pro forma, you tweak it here and there, and you submit those.
My lady, we have to use a standard pro forma. That is no secret. And you cannot just write what you want to write. You have to give certain aspects through to the Honourable Court. And I went on a forensic report writing course, and also Justice College prescribes a certain pro forma to us. So we are to a certain extent limited or bounded. The way in which you draft it, that is your own personal opinion, or you can change factors in accordance to what you feel applicable. But yes, we do have a standard pro forma.
You see, I've standard in terms of format, standard in terms of the way it's written, it's not a problem. But you are unable to explain what you meant by to deter others would-be offenders from doing what?
I don't know if I should read what I've got under the deterrence and prevention, my lady, if that would be of assistance.
No, I've read that. You can't read it because if you read it, and you're welcome to, I'm not going to stop you. But are you dealing with page 14?
That is correct, my lady.
Now, if you read further, it's not in the public interest. Where do you deal? What specific aspects as far as deterrence did you take into account there? And please take your time and read it because it's important to me. I've seen this. You deal with deterrence, but I don't see it.
Can I read it, my lady?
And no, please don't read it. Point out what you want to point out in that particular paragraph.
I'm not actually sure what the advocate, if I want to read it, he says, no, I can't read it.
Should people be deterred from firing shots?
Not everybody needs to be deterred from firing shots, my lady.
Should people be deterred from
when people
firing 4 shots through a locked door in the middle of the night?
In fact, so, my lady.
Yes. So, a sentence by this court should say, people should be deterred from arming themselves, walking to a bathroom, firing shots through a door in circumstances that a reasonable man would not have fired. That's what we're dealing with, deterrence. Am I wrong?
No, my lady.
No, what? I'm not wrong.
No, my lady.
Okay. You see, the interesting word choice is I asked you a question and you said, I can only give evidence from out of my own framework and in things that I know and how I understood things. Remember, you just answered like that.
That's correct, my
Good.
lady.
Now we go to page 15 and we deal with within his framework again. You say, the accused has accepted responsibility for his crime from within his own framework. Now, remember we dealt with it yesterday, but it's now just easier because you used the word again. What do you mean by within his framework?
From how he expressed himself, my lady.
How did he express himself?
And again, I stated to the Honourable Court that I had the judgment, so I do not obtain additional information. I went through the judgment with the accused. I've underlined certain factors. The accused, from within his framework, adhered to, or there were things that were said by the accused, which is also in the judgment, my lady, that he fired the shots. I don't think that is in dispute. I don't think that the accused fired knowing, or he said that he did not know the deceased was on the other side. So from within his own framework, but that is already in the judgment, my lady.
Okay. Firstly, we'll deal with all this. You first said, when I ask you, what does his framework mean? You say the way he expressed himself. So he expressed himself to you, explaining his framework as far as the judgment's concerned.
That is what we stick to, my lady. I did not ask him beyond that.
Now, you said, and that's something we didn't get yesterday, he said to you he did not know the deceased was behind the door.
But he did not have the intention to shoot and kill the deceased. That is correct,
intention
my
we
lady.
have. But he had the intention to shoot at the door knowing there was somebody behind the door, or did he not say that?
You'll have to refer me to that specific
No,
space.
I'm asking you within your dealings with him. He fired at the door, intentionally firing, knowing there's somebody behind the door. Did he say that, or yes or no?
He admitted to shooting through the door, my lady.
You see, was it an accident? Did the gun discharge by itself?
No, my lady. I know that he said that he was in shock and that it just happened very fast.
Did he say to you, when he never intended to shoot? Did he say that to you?
I can't recall those words, my lady.
What words do you recall?
My lady, again, as I've said, the accused said he thought there was an intruder gaining entry through the home, coming to attack him. Those factors are placed before the Honourable Court. His version of the accused was that he fired shot at the toilet door because he thought there was an intruder inside the toilet. I'm not
Okay.
sure what else do I
Good.
need
No,
to
no,
repeat
that
to
is
the
perfect.
court.
Yeah, that's perfect. What are you reading from at the moment?
From the judgment.
Are you reading from the judgment? I'm dealing with what he said to you, madam. You said within his own framework. So,
That is correct, my lady, meaning from within the accused. But we did not go beyond what is in the judgment.
Paige, what are you reading from the judgment?
3347.
3347. You say the accused accepts that he was negligent. What negligence did he accept?
That he fired the shots, my lady,
He
and that
accept,
a person was killed because of the shots fired by the accused.
so you say accused accepted that he fired the shot into the door and that knowing there was somebody behind the door. And that was negligent. Or did he say that to you?
No, my lady, I cannot put words in the accused's mouth, so I
I'm
cannot
asking you, did he say that?
recall.
Yes or no?
No, my lady, not
Okay.
that I can recall.
So if you say you accept that he was negligent, what do you mean by that? How do you know that he accepts that?
He stated that he fired the shots, my lady, that killed the deceased.
How do you know he accepts it?
I can only say,
Isn't that the answer?
Did he say that in the trial or did he say it to you?
he said to me, my lady, that he fired shots that killed the deceased.
I know that you say this accused will not reoffend, and I'm not saying he will, but you were also the probation officer in the Steyn matter.
That is correct. In fact, so, my lady.
Now, the Steyn matter is what we become known as the Sunday rapist.
That is in fact so, my lady.
Now, before you became the Sunday rapist, you did the probation officer report on 3 counts of indecent assault of young girls.
That is in fact so, my lady, and I'm actually very happy that the case was brought up again today, because it seems that there's only one case, and recently after the successful appeal of Jub, I've now got 2 cases that I've done in 28 years. The case pertaining this particular accused, my lady, is so far from this case that it is actually good that we bring it up, because I don't see why it has to be brought up. But I'll discuss it with my lady, or just give my lady some of the facts. This is a sexual predator. He was receiving treatment and therapy for his sexual behavior. During the time he was with or seeing a psychiatrist and a psychologist, whilst under therapy and treatment, he was actually told, because he had progressed so well, that he should go to court and admit to his deeds. There were no initial charges brought in against this person prior to the case being brought to court. He then went to a lawyer. He and his lawyer went to court, and the accused, the psychiatrist reports, and with the knowledge of the state, accepted that correctional supervision would be a suitable sentence option under those specific conditions and circumstances and facts placed before the court. Subsequently, it has been pulled out of context, and because people only know the name, it is in 28 years, as I've indicated, the only case that I've basically dealt with. It is so that he did in fact obtain community corrections. Again, my lady, I did not make such a recommendation. In my report, I stated that he was a suitable candidate towards community corrections, based on the facts that were available during that time.
You see, I'm glad you put it into perspective, and I'm not attacking you for what you did. I just want to refer you to your report.
Not at all,
One
my
of the
lady.
factors that played a role here is he had remorse and insight into what he did. That was what you said.
He actually approached the courts. There were no charges brought in against him, my lady. And if he did not bring his attorney and on the recommendation and the motivation of his team, he would not have pleaded guilty. But he felt that it was the right thing to do during that time.
He has expressed remorse and realized the seriousness of his current position. That's a factor you took into account.
That is correct, my lady.
He's expressed remorse and had insight into what he was doing.
That is correct, my lady.
You said further, but now your view at the time was that he would not reoffend.
My view could only have been on the facts that I have
Yes.
obtained during that time, which was based on the psychiatric treatment, the feedback from them. The case was so old, my lady, that they battled to find the sources and the victims and the complainants, and they actually went on the facts that was provided by the accused and was investigated on his behalf.
But you had the view that he would not reoffend, and I'm not saying we're always right. I'm just saying in that instance it was wrong because he offended immediately thereafter.
Yes,
That
but
would be a-
Mr. Nell, if I might just intervene. It's the likelihood
Yes,
that we're talking about,
Yes.
isn't it?
that's what I'm saying, my lady. And,
Yes.
I link it to remorse, and I'm going to remorse now. And that is the reason why I'm doing this.
Yes.
I'm not saying this person was wrong and she should have done something different. I'm just saying it happened. So I'm not attacking her on it.
Okay. No, I hear you. I just say
Yeah.
we must
It's
put
a
it in
likelihood.
context.
Yes.
It is just a likelihood. It's not a certainty. Yes.
And it's an opinion. Yes. No, I have that. But what we have in the Sunday rape is this. He was there. You were under the impression that he had remorse and insight and he would not reoffend. And as far as you were concerned, the likelihood that he would not reoffend was there. But he did.
That is in fact so, Your Worship, and that was my opinion based on the facts that we had for that particular case during that particular time.
Good. Madam, can we just say... in terms of the two counts we're dealing with, culpable homicide and negligent handling, you know that the negligent handling happened before. He was negligent with a firearm in a restaurant, and months later, again negligent with a firearm in his house, which caused the death of the deceased. You know, it was only months difference.
That is as far as I could ascertain from the judgment on 3281 and 3282, if I'm correct, my lady.
Madam, we dealt with it yesterday. The two issues that you've mentioned to the court that you feel that, in your opinion, should be taken into account when the court would even think of imprisonment would be the accused's disability and his state of mind. Is there anything else?
My lady, if I may just broaden it a bit from a social worker's perspective, I can hear what the Honourable Court is asking me, but it is so much wider than just that. And I have incorporated that in my report, because his state of mind or the physical disability, and I'm not an expert on that, it's not just the fact that he is physically disabled, the fact that there are limitations to that, the fact that he needs to clean them, the fact that he needs to rebandage. the fact that there are many factors contributing to that. And the same with his psychological. I'm also not an expert on that, my lady, but concerning the accused's personality, his vulnerability, and all other aspects that were already placed before the Honourable Court by the concerned parties. Then also the factors as mentioned on page 18 and 19, my lady.
Let's deal with that. Firstly, as far as disability is concerned, we touched on it early this morning, but do you have any statistics about disabled people in prisons?
No, my lady.
Now, if I put to you that on average over the last 10 years, there were 128 disabled prisoners admitted into the facilities yearly and were dealt with by the prison, you won't be able to deny that.
I can't deny that, my lady.
Now, if I just take task with you on page 17, the last sentence, there is also no facility to cater for the accused's disability. If I tell you that that is not correct, that the correctional services would be able to cater for any person with any disability and have been doing so for over 10 years, what would you say?
I'd have to take note, my lady.
As far as psychological treatment's concerned, you have yesterday admitted that prisoners, inmates, would be able to consult their own private practitioners in prison. Am I right?
No, my lady, I did not confirm that, but I knew that they were able. I think the question was put to me that they would be able to bring in their own psychologist or psychiatrist.
And you don't know that?
No, I said that I took note there of, my lady, but there must be costs and additional, I would say, procedures to be put in place. And I think then the advocate also said to me, but if it's a paid treatment, so whether they pay for the inside or the outside, that would be the same. I've also incorporated, yes, my lady, that there are psychiatrists available, but that is in my report. But that is also to the availability of the people and not specifically known to the accused.
Madam, I'll just put you don't know this, but I'm going to put it on record. You don't know the Correctional Services regulations that was issued in terms of the Act.
No, my lady.
Regulation 10 deals with correction, development and care programs and services. Now 10(3)(b) deals specifically with the following. An inmate may also utilize his or her psychologist of choice, but at own expense. So, in terms of regulations, that is possible.
It's possible, my lady.
So, disability, we've checked. The correctional services can accommodate this. As far as psychological assessment is concerned, we've checked. He can either see his own or, in terms of the regulations, I've now dealt with regulation 10(3)(b), but 10(3)(a) reads, psychological services must be available to all sentenced inmates and prisoners under community corrections who have need for such services. So in prisons, there must be, in terms of the regulations.
That is true, my lady, because often if they are not, they rotate. But one has to be practical and realistic, and I presume the state witness will also then be able to testify on that there are not always psychologists or sufficient available, and that in some prisons they rotate to render a service. Okay. But the mere fact that there are services available, I think one should really be realistic and not just say it's their ticket off. One has to be realistic about the quality of the service. Is it really going to benefit the accused if we have a complete stranger, and I'm not saying that he has to be benefited by the process, but if we are looking in terms of it has to benefit him, he has to grow through development so that eventually he will be released into society as a useful member of society. At least we need to not just tick it off and say it's been done. We need to accomplish something through that. So I take note of that, my lady.
So other people that are not Mr. Pistorius, that are in prison, you say the psychological service, as far as you're concerned, standing there, it's inadequate. Or not? We can't tick it off if it's available.
I did not say it's inadequate. I just said that there aren't always psychologists available, my lady. I was informed that there were not sufficient psychologists available.
But you know, madam, that's one thing about what the service provision and how the specific facility would manage itself. I'm not saying that all prisons in South Africa, and neither would Mr. Smallburger sitting next to me would say that all prisons in South Africa are the best places in the world and that they all function as they should. We're not saying that. But we're saying it is available, there are regulations, it could be enforced, and that you cannot deny.
I cannot deny the regulations, my lady, but I really believe that one should be practical and realistic as well.
Then, I've read through your report last night, and I'm going to ask a general question. Having read through your report and the emphasis on physical facilities for a disabled accused and psychological facilities for a disabled accused, there's lots of focus in your report on those two things. Am I right?
It is in fact so, my lady, because you have to individualize concerning the accused before the Honourable Court.
And I went through your report, and we will get there. If one reads your paragraph at page 21, it reads, are you there?
I'm here, my lady.
21, I think it's the second paragraph. It also permits the required psychological and psychiatric treatment within an acceptable atmosphere. That is if somebody is outside. In context, let's read it in context. You say in terms of 2761H, if it permits the required psychological and psychiatric treatment within an acceptable atmosphere. Psychological and psychiatric treatment in the atmosphere of imprisonment will rather have a negative effect than positive impact on the accused. Is it only this accused or all people that need that?
Concerning this accused, my lady, he will no longer be able to pursue with his current treatment and therapy. I think the psychologist or the psychologist or witness that testified had already indicated that he needed further therapy and treatment. So it would be applicable. We're not speaking about other people here. We're speaking about the accused person.
So it's not so much the facilities that you're saying are wrong. You're saying that there are facilities in prison. Some people may use it. This person, this particular accused, will not benefit. Or am I wrong?
My lady, I attempted to place before the Honourable Court that if you are currently under treatment and therapy and that is changed, it will impact on the accused person. So I don't know how else to put it.
We see, madam, on these sweeping generalizations in your report, so if any accused is undergoing psychological treatment before he gets to court, you will have to advise that he's not imprisoned. Because that's a generalized statement you're making.
I'm sorry, my lady, I did not understand
okay,
that.
I'll try it again. On your generalized statements in your report, if an accused, other accused, is receiving psychological treatment before he's convicted, you will have to advise that he's not imprisoned, because then that treatment will stop.
I really do not understand the question, my lady. Does the treatment or the therapy has to stop, or is it his personal treatment?
Yeah, his personal treatment. If he's undergoing personal treatment.
No, that can pursue. We've just placed that before
But then
court.
it can pursue for this accused as well.
But that is if he has the funds available, my lady.
So, okay, let's just do it for the other accused. If another accused does not have the funds available, he's undergoing psychological treatment. But before I go there, my lady, I'm interrupting myself. So, if this accused does not have funds available to pay for private psychological assistance, he would not have that if he's at home in terms of 276C as well. IH.
Unless he has the opportunity to pursue with some form of a career or obtain employment. That is correct, my lady.
So, yeah, but let us just deal with this. If we're talking about funds, if he doesn't have any funds, it doesn't matter where he goes, because he won't have the funds to pay the psychologist if he's at home, if he doesn't have the funds to pay her when he's in prison. Am I right?
That is correct concerning psychological treatment,
But
my
then the
lady.
court can do him a favor by sentencing him to prison, because it's free and it's available. Because in prisons we have that.
That is correct, my lady.
Good.
But I'm not sure if it's going to be a favor.
But at least if funds is a problem, he would not have to pay for psychological treatment in the prison.
It's not, there are no fees applicable, my lady. That's very true.
Good. Lady, I'm paging through the report. I've marked certain things. Some I would not touch on, so if the court just grant them. Let's deal with page 23. Now, where you deal with the negatives of correctional supervision. Do you see that under the heading negative?
I do, my lady.
So some people in the community may perceive correctional services supervision to be a light punishment. Am I right?
That's correct, my lady.
You have to agree with me, madam, that society demands that if you kill somebody, that there should be a harsh punishment.
I cannot dispute that, but I would like to put it in context, my lady. We cannot just have certain, we have to individualize, we have to look at circumstances. We have to look at the circumstances concerning the crime, and we have to look at the accused in totality. So we cannot just say, yes, it's a serious offense, let's categorize it and put it in block A, because we need, then we're going to have, or don't need a justice system, because then we can say this is a serious offense, it falls under category A, this is a sentence applicable.
So how do we do that in a culpable homicide case? We look at the degree of negligence. Or why would you do that? Or would you just merely because it's culpable homicide categorize it?
There will be factors applicable to that specific case,
What would those
my
factors
lady.
be?
That would depend, my lady, whether it's, say, for instance, a motorcycle accident, a motor car accident,
Yes.
people involved, and whether it was, everybody, I would say to presume, is negligent to a certain extent, but one would look at factors.
Yes. So, even if you're in a motor vehicle accident and people die as a result of the accident, people are imprisoned. We have Jib Jib, a case you know well. He was in prison for 20 years at first.
That is so, my lady, but there are also cases where people don't go to prison for the same Mendoza, which is one which I haven't been confronted with, but he did not go to prison, my lady, so there are exceptions.
And,
And it cannot be just generalized that everybody for culpable or a specific sentence should receive a period of direct imprisonment.
do you know about and I'll refer to that in my head, but do you know about the matter in Cape Town, Humphreys, the driver of the bus with the school children in it, and that tried to beat a train over the tracks and got involved in an accident? Do you know anything about that?
My lady, I'm very cautious now to say no, because it can be one of my cases, but not that I can recall quickly.
I'm not saying no, I'm not doing that. But, Madam, can I just ask you, and I have case law which reads, and I'll read you a specific portion of a case where the judge said, taking the life of a fellow human being is always a serious offence which leads to outrage and demands heavy punishment.
That is so, my lady, it cannot be denied.
And that sentences should indicate to society that our courts and society value human life. Do you agree with that?
Absolutely, my lady.
You see, my lady, the matter that I refer to now is not a culpable homicide matter. I refer to a sentence out of a judgment that this court would know well. It's in the Tatana case.
How do you spell that?
THTHANA. It's 2008 JOL 21307.
I know the case.
I'm sure the court knows the case very well.
Yes.
And yeah, and I read a portion from that. Now, Madam, if a member of society would look at this particular case and think that a person, this accused, got up, armed himself, walked to a bathroom, shot 4 times, caused the horrible death of the deceased, don't you think that society would want a heavy punishment?
Society would want the accused to be punished, my lady, but I do not believe that it is in the hands of the society to punish him. That's why the Honourable Court has to take all factors into account for purposes of sentence.
I'm dealing this with society. Society would want the courts to punish him and to ensure that people are more careful in future. You agree with that?
I cannot dispute that, my lady.
And let us just look, and it's technical aspects we will discuss when we argue sentence. But what you're recommending is the accused is under correctional supervision, which is house arrest at his house. Am I right?
House arrest forms part, or the Honourable Court can make it as a part of condition for purpose of community
would you
corrections.
Want that? What would your recommendation be?
I would most definitely consider that as an option. It needs to be incorporated.
But the accused can, and you said it, the accused could be allowed to pursue his athletics. He could go train, or he could find a job and go work and return to his house.
That is so, my lady. That is part of the conditions of correction also, that the person has freedom of movement to a certain extent, as they are not perceived such a danger that they should be taken out of the community, so that they are allowed to pursue a career, which I think if we talk concerning the specific accused here, the running or the sports would mean part of the career, should he be able to pursue that.
Are you only making provision for dangerous people to be taken out of society?
Not at all, my lady.
You agree that lawyers are sent to jail regularly, not regularly, but it has happened that lawyers who would steal trust funds would be sent to prison?
My lady, I've dealt with a person that took a slice of cheese that was sent to prison. So I've dealt with cases which were completely on the opposite side, and then I've dealt with cases on the other side which were just as serious, and people did not serve a period of direct imprisonment. So again, it would be based not just on the seriousness of the offence.
But we're dealing with society at the moment. We send people that defraud people out of money to prison. And they're not dangerous, am I right?
They are a danger to the economy, but not to the society or the people.
But so if somebody's a danger to the economy, that you would think that he should be in prison?
Not at all, my lady. Again, as I've indicated to the Honourable Court, one will take all factors into consideration. That's why sentencing vests in the hands of the Honourable Court.
So you don't have a problem in sending people that steal to prison in certain circumstances? That can happen?
My lady, may I just try to... it's not me sending people it's to prison. It sounds, and I'm not even sure if I'm allowed to smile here today. It's not a matter of sending people to prison. I can only merely give an opinion to the Honourable Court, which the court makes a final decision on the sentence. And even if I give an opinion, the court is nowhere binded by my opinion. It's merely an opinion.
We all know that, madam. I know that you cannot bind the court. I'm asking you, the opinion, your opinion. In your opinion, it would be correct to send people to jail if they steal, or would it not be? Under circumstances.
Under circumstances again, my lady.
And theft, and fraud.
Under circumstances again, my lady. When
Now,
taken each and every individual case into consideration.
What we have in terms of an option that you've looked at is 3 years that the accused is under house arrest, and he goes out and he has to pay back to society 2 days a month. That's all. And you think society would be happy with that sentence for having killed somebody. That's all.
Again, my lady, and I think there is a sentence in the report. It's not about the opinion of society, but the public interest, because everybody has an opinion. You cannot satisfy the public opinion, because as we are sitting here, people are divided. People are divided everywhere. So the court has to take the factors into consideration and not just the interests of society.
But you also agree with me, and I'm sure you've been referred to the matter before, that if the court sentence is too light and society loses trust in the courts, they will take the law into their own hands. That's what the court has to guard against, am I right?
I would agree, my lady, but again, I would say with the greatest of respect, we cannot take a sentence option which I did not impose. It's imposed by justice. And if it shouldn't be there, if it's not a harsh or harsh enough sentence, or if it's not as a deterrent, or if it does not serve a purpose. So it is there because it serves a purpose.
For certain matters. For certain matters, you're right.
That is for the Honourable Court to decide. It is not for me to decide.
But we're looking at this matter, and I'm saying that the option that you mentioned in your report, that this accused be sentenced to 3 years correctional supervision with 16 hours a month correctional duties, is shockingly inappropriate. It cannot even be considered.
I can take note of that opinion, my lady, but I've had cases of culpable homicide where people were sentenced to community corrections, where it had served as a deterrent coupled with a severe suspended sentence and taken other factors into account.
Now, when you prepared your report, you looked at correctional supervision and you drafted the report. You didn't go through it in your evidence, but you did on what you suggest the court can look at, where the accused could do community work at the Brooklyn or closest police station or something like that. Then Mr. Roo asked you if you don't think it's also an ladies, page 26, also an option that he should work with children. Remember?
I understood it to be more disabled children,
Yes.
unless I understood it incorrectly.
But, and you were correct by saying, for correctional supervision to be a sentence at all, the person should be taken out of his comfort zone. Comfort zone is, I work with children, I love doing that, this is what I've been doing my whole career. But for correctional supervision to be effective, a person should be taken out of her comfort zone and not do what he's been doing all along.
I cannot dispute that, my lady, and that forms part of the punishment.
So the fact that he should just carry on work with underprivileged children that he would have done in the past and what he would love to do, that is not an option, because that would not make correctional services, it would not take him out of his comfort zone and make it a punishment. Am I right?
That's very true, but on page 26 I indicated, my lady, that he can also work at a police station. I know that the previous witness stated a museum. They have specific places where they do community work, and the reason they have specific places is for purpose of monitoring, because it's very difficult if each and every accused decides to go and do some voluntary work at his own place for a department, a state department, to be able to monitor those functions. So it is so that they have a preference to specific places where they know there are people appointed and available to ensure that there is monitoring.
Madam, the opinion expressed about custodial sentence options at page 32 you have dealt with the seriousness of the offence. What's the seriousness of the offence in this matter that you took into account?
I think the manner in which she passed away, my lady, I think the severity of the crime in such as a loss of life that can absolutely never be replaced, irrespective of the fact that I was able to communicate with the deceased family members. The impact on the deceased family members can never be disputed, and all the circumstances already highlighted in the judgment by the Honourable Court are factors taken into account for the seriousness of the offence.
Madam, can I ask you that just the paragraph, the first paragraph, where you say one of the main problems is the fact that prison environment is not conducive to therapy, and in particular not conducive to successful therapy of the accused. Again, why do you refer to the accused? Why is it in particular not conducive to him?
My lady, again, I think I attempted to address this question earlier. The report is for the accused person. So concerning the accused, he is currently receiving treatment and therapy. It would be different from the treatment and therapy that he can obtain. So it would be different in the end.
Okay. But you're not saying with that paragraph that every person suffering from PTSD after an incident should not be sent to prison because the prison environment is not conducive to therapy. You're not saying that?
Not at all, my lady,
Okay.
because the prison environment is there to secure the public and the people from people who are really and honestly a true danger to society.
Now, if we look at page 33, where you mention and deal with the where you deal with the specific disability, if we could convince the court that within prison they would be able to cater for the specific accused, that whole portion would fall away.
That
Because you're saying that because he will find it difficult to walk on his stumps on the cement floors, because there's no rail in the showers, because of those two things, you would advise against a custodial sentence. But if correctional service would say they can cater for this accused, that is a factor the court should take into account.
My lady, it is also always a fact that the Honourable Court can take into consideration that the accused can be sentenced to a period of direct imprisonment. But we can also look at other options available to the Honourable Court. If they can confirm that the accused will only be bounded and limited to a hospital section for the duration of his sentence, I presume that would be a different aspect to look at. But then we can also look at the accused instead of having to be subjected to a specific section, because then we can again say, why are we making an exception to the accused? Why would he be the one to be sent to a hospital section? So again, we're going to have these questions, my lady. I just believe that I cannot say that the accused person per se, there are alternatives available.
Then, okay, so we dealt with that, but you see, what bothered me about your report, but I understand you only focused on the accused, but all the factors mentioned by you will apply to other prisoners as well with disabilities. It's not only this accused.
I can't dispute that, my lady, but that would be a specific person that has no legs or whose legs have been amputated, if we speak about the specific accused.
But a more vulnerable person, we have an accused that can walk. If he has his prosthetic legs on, he can walk.
That is true, my lady, but should he be pushed on slippery floors, it would be different to a person in a wheelchair that is more mobile, that would be able to at least be more secure or safe. I don't say that any other person won't be vulnerable. We can talk about a person without an arm, or maybe a person that's not able to walk properly. There will be factors to be taken into account on each individual case.
You see, madam, every time you I don't want to use the defend, but every time you motivate why this accused would have difficulties in prison, I ask myself the question, you would never even think that a person like the accused, for whatever they've done, should be imprisoned. And that bothers me because of the facilities. Am I right or am I wrong?
My lady, we're not discussing anybody else here today. It is about the accused person before the court.
Yeah, but let us take the accused person. Whatever is done, let's say yesterday we tested you and say, if this accused was convicted of murder, Tolus directives, the facilities would have been the same and your recommendation would have been, or not recommendation, opinion would have been the same. He cannot go to prison because of the facilities.
I cannot say that, my lady, because I do not know what the circumstances concerning the matter would have been. It would have been different.
But the facilities would have been the same. We're just dealing with facilities. They would not have changed. And that's what's bothering me.
The facilities would have been the same.
So then your opinion must have remained the same. He cannot go because of the facilities. Doesn't matter what he's done.
With respect, my lady, but the state advocate limits me when I try to say something when it comes to, it's not just about the facility. He tries to tell me that if the accused had committed a murder, and I do not understand the rest because it's not in Afrikaans or English, but the Tolus...
Okay, well, are you looking for those evangelos and those directors and those things?
Yeah,
Okay.
that was added. For purpose of that, my lady, I cannot elaborate on that because he wasn't convicted on that.
Madam,
I can just elaborate on what he was convicted for.
but I've just been informed that it's past 11.
does that mean?
Should we perhaps take a tea adjournment? I won't be very long after that, Mary. So
We'll take our 15 minutes break. Court will adjourn.
Battery's going a bit low, but I've got other ones.
You're on, David, you're on.
Well, I'm just going to change the batteries.
Very hard to sometimes hear it.
Geo trying to follow Shane desperately into
Well, okay.
You don't want to change the battery now. I'd change it. Marcel's a ninja. Okay.
I can make two batteries.
I want to put this inside the coat. Say 15 minutes, Jim.
Yeah, it's quite short. They're about 7 minutes away from us. 6 minutes now.
It'll be short.
I presume so. Just in case, David, I will give you the fourth signal in case you...
That's why I was having my Red Bull.
You're rather going to do it outside. Okay. Take better picture. Nicer background.
My lord, I'm falling asleep. At least the chair that I'm sitting in.
Hey, that was fun, eh? Oh, okay, so at least you can hide. Hide, yeah, we're hiding.
Pick up the chairs.
We're hiding in all the snooze on the floor. I'm about to say that's all right.
I've lost my camera back. Go with your piece now again, man. Can you stand on this side from me, please? Thanks, David. It's all just precious.
I've been meaning to ask you, is there anyone we can ask for that 3 p.m. slot?
Yes, and I was thinking about that. There is someone, I'm sure. David Smith?
Please, David's in court.
David's in court, the main courtroom, we can ask him.
Sorry, just give me 1 sec. Are you hearing studio, David?
No.
You're not hearing it. David's not hearing studio.
Chair, why did you wear shoes like that?
Because I won't be able to take 2 steps in there.
Because you don't want to look like a complete cheap slut either.
I just can't walk in there either. You know what I
Oh,
mean?
so cheap slut's got nothing to do with
No.
it? Oh, okay.
I would try to walk in there, but no. No man, geez, you'll kill yourself trying to walk. I battle after a short day just with this little hill. 'Cause I'm used
Okay,
to
I
humps.
got them. Graham?
David's got...
Just got it now.
Thanks, Leon.
Oh. Roloff he's a master at all of this, eh?
There we go. Got it.
It does
Got
actually
it.
suit you.
That came too naturally. Too naturally.
Yeah, yeah.
Now you just knew what to do straight away.
I just want to see Gio quickly.
Starting to rain.
What's nice feel of Gio? See the other team.
Hey. Yeah. What's his name? Sunday rapist Yaku
Stain.
Stain.
Feels smattering of rain.
You're lucky that bird didn't shit on us. Eh?
Yeah, that scaly thing must fuck off.
Yeah.
Is weer amper 9 minute weer terug naar Port toe, so hulle moet nog vinnig kom. Kan nie wees nie, ons is amper weer terug in die hok.
Hardloop het gaan en sê vir jou dan, get onto your headset.
Is dit nie op sy headset?
Nee.
Wat sou met voor moet sê met dit afloop?
Seker gaan. Seker gaan. Sê maar nog gaan maar dit is toepas.
You're not here, Dave?
I'm trying to work out who's in the studio. I think it's Dadich.
It's Graham speaking.
Can't work out who the other voice is.
Yes, I just got a missed call. Okay, okay, right.
Might be James Grant.
Now comes the sun again. Crazy weather.
Just don't rain for our afternoon crossings.
Hey?
I'm saying it mustn't rain for our afternoon crossings.
The clouds look quite high now.
David, sorry, can I ask you just to stand like a half a step in front of her? And so look more towards.
Okay,
towards me when
then
you
it makes
walk.
me even higher than Gia. When I looked at the shot of us yesterday,
Yeah.
it looked like I was leering
Yeah.
over you.
Yeah, you were
Crazy.
quite tall next to me, yeah.
What if we move back, it just stands on the curve.
What if I stand forward a little bit? Wouldn't that work?
I can hear you, yeah. So Graham, it's the quick chat and then turn to chair. David.
We can keep it quite short. See,
Hey?
they're coming to us.
Yeah.
And Debbie's going to throw to you. Keep it quite short.
Okay, and how do I throw back?
Just trying to find my script. If I give you this, you throw back to studio. This is...
Throw back to break and then throw to court.
Guys, just tell me, where's David going after this? Does he throw back to studio? There's my, sorry, I missed my email.
Thanks very much, Debbie. Well, we've had a smattering of rain a little earlier. The sun's starting to come out. Inside the court, a deluge of criticism being heaped on Annette Vergeer by Gerrie Nel, over and over again, calling her utterly irresponsible in the way she's assessed the conditions of the prisons in South Africa, asking where she got her information from, challenging on it, looking at what she's been saying, what her opinion is, and asking how she verified the information that she is putting forward. And on most of the occasions, she's unable to say how she verified it, if at all she did. At one stage, she offered the suggestion that she had spoken to a social worker from the Department of Correctional Services, whose name she could not divulge. This person did not want to be publicized in court. And that was as good as she could offer. She did not verify if this person was indeed the correct person with whom she should be talking. But when it came to the issue, and Gerrie Nel chose the example of baths in correctional services facilities, she and pointed out that there are a number of places where there are baths. He kept challenging her, why did she say there were no baths? Quite frankly, she could not answer that question, and all she could say over and over again when she was stumped for an answer, I take note of that, my lady, which really wasn't cutting much mustard for Gerrie Nel at that stage. He also brought up the issue of a case that she had been involved in, providing a report on the Sunday rapist. Now, Gia Nicolaides from Eyewitness News is with me here. Tell me what it was that Gerrie Nel was trying to do as he raised this case of the Sunday rapist.
Well, David, he was actually trying to just compare the two instances where she had made a very similar recommendation in terms of Jaco Steyn, a man who had indecently assaulted several women. She had recommended correctional supervision, and he was doing community services at the time and receiving therapy. But while under correctional supervision, he committed the same crime again. He reoffended, and he went on to rape several other women. So he was using that as an example as to how her recommendation didn't really work in that particular instance. She didn't believe at the time that he would actually reoffend, and she said that in this particular case that she doesn't believe Oscar Pistorius will reoffend. So he's actually compared the two cases and said, where does the credibility lie? Could this happen again where Oscar Pistorius reoffends because of her recommendation?
Thanks very much, Gia. Well, what we've also got is a continued tussle about the severity of the sentence versus the nature of the crime. Back to you in the studio.
You're still under oath, ma'am.
Thank you, my lady.
Thank you very much.
May it please the court. Madam, can we just go to page 34,
Just
please?
Before you start, I just want to find out, is the machine now in order? Okay, so there was nothing lost. Okay, thank you very much.
Everything was recovered with the backup machine.
Thank you. Thank you. Yes, you may proceed.
Page 34, please. At the bottom, you see point number 8 that you're dealing with. You say that psychological treatment in prison will be negative, as the accused needs to be treated with due regard to his extreme emotional state and vulnerability because of his disability. Then you say, correctional services do not have the treatment facilities available for a person such as the accused. And the probable result will be to break the accused even further. What are you saying there?
Concerning the current circumstances, my lady, that the accused will again have to make use of other facilities available or applicable due to his current status.
Now, if you talk
or
about
versus the current status.
now, what facilities are we talking about?
Well, we're talking about the psychological and psychiatric treatment facilities available, which is applicable to the accused person.
Okay, but we sorted that out with the fact that he could have access to his own. It's a possibility.
As a possibility, my lady.
You say that he is a broken person. He's a broken person because of what he did. Am I right?
It is the totality thereof, my lady. I cannot dispute that the circumstances which has all contributed to the fact that the accused is in fact a broken person.
And we have to weigh that up against a broken family who will never get a loved one back.
Not at all, my lady, and that's also placed before the also not placed before the court in such a manner. It's just that we are speaking about the accused person here.
And then we go on the next paragraph, paragraph 9, where you deal with the offender's sentence begins the day that he is sentenced, not the day that he is sentenced by court.
That is in terms not of the legal aspects, my lady, but in terms of the manner in which people feel and what they go through.
But it's because of what they did.
That is not disputed, my lady, but it can still not be denied.
But they're not victims.
We never said they are victims, my lady, but they still have emotions.
They have emotions, but they're not victims. We have different victims. This accused is not a victim of what happened.
We never said that, my lady, but he does not become a stone or a person without emotions, or a person that will not be sentenced, or a person that will not have to go through all of this. And all of this has to impact and has impacted on the accused person.
And so it will impact on every accused person before court that have killed someone.
That is not disputed, but each and every person will automatically go through these stages in a different manner.
Now, the one aspect, I'm going to put to you that if I read your report, you make sweeping statements about conditions in prison, and although you say you don't do it, you're against sending this accused to prison on your sweeping statements about facilities. Am I right?
My lady, again, with the greatest of respect, I'm not sending the accused to prison. I have no option in that, and I'm not responsible for that. I can only make give or provide an opinion to the Honourable Court to say there are alternatives available and why they can also be a suitable sentence option. In this particular manner, I cannot dispute that I said that a sentence such as a community-based sentence would serve also as a deterrence. It would deter, we are talking about the accused person, other people could, or that do not view correctional supervision as a light manner, can see it as a deterrence. There are so many factors to be addressed through other sentence options that direct imprisonment is not the only option available to the Honourable Court.
Madam, and talking about sweeping statements, almost done, but 38 is a clear indication. At page 38, you say containers of condoms are freely available in the and the realities of AIDS are no longer denied. Why is that a negative factor that there are condoms available?
With all due respect, my lady, why is it a positive factor? It's a male prison.
Are you discriminating against consensual homosexual sex?
Not at all, my lady.
Why are you then against condoms in prison?
It's not that we are against it, my lady. It is just the exposure that people who go into the prison environment will be exposed to, with or without their choices.
No, madam, I don't understand that. And this is just a clear indication of your bias against prisons, is that you would mention that in a report, that there are condoms available. Why is that negative?
If that's a reality, my lady, I can't see why I can't mention it.
But why would you mention it if there's condoms available in every store in the country? Is that a problem?
We're not talking about a store
I'm
here,
talking
my
about
lady.
stores. Is it a problem if there are condoms available in stores?
There is not a problem if there are condoms available, my lady. But where we are talking about a facility where people should be able to enforce choices, it would be a different scenario.
No, I don't understand that. So let's see, if there are condoms available in government buildings, is that a problem to you? In toilets in government buildings, is that a problem to you?
No, my lady.
Why
as
is
we
it a problem?
have-
Yeah. Why is the problem for you in prison? And how do you bring that to choices?
As it could limit people's choices, my lady, but if it is a positive, at least we have mentioned it.
No, that's not that easy. I'm talking about your bias against prisons. And that particular paragraph, when I read it, bothered me. Why is that a negative?
It is a fact, my lady, so it was mentioned as a fact, not per se as a biased option.
What about other facts that there are water in prisons or there are gardens in prisons? Why would you mention condoms? And why did you link that to choices?
As it is something, my lady, where people are being sent, whether they have choices or not choices, they are being sentenced to a facility where they will be restricted for a specific period of time. And irrespective of your choice, whether you choose to go along with a certain or a specific group, whereby condoms could or should or would be used, it is also affects other people.
No, I don't understand that. I don't. Except I hear lots of bias in what you're saying. But apart from that, about other groups, I don't understand it. Please explain that.
My lady, the condoms would not be applicable to everybody in the prison.
But the mere fact that it's there, why is that a problem for you? Why would you mention it?
It is not a problem, my lady. It is a fact. That's why I mentioned it.
No, you see, madam, the inference I'm drawing, and from your first answers, is that you link something else to condoms. What do you really link to condoms, and why did you mention it?
I do not understand the question, my
You
lady.
don't? Okay. So you don't have a problem with consensual homosexual sex and the use of condoms?
Not at all, my lady.
So that's, in fact, a positive thing that you mentioned about prisons in your report.
It is a fact, my lady, which is visibly available, and if it's used by everybody, I presume it's fine.
So you don't have a problem anymore that people are exposed to condoms, even though they don't have a choice to be in prison. That's not a problem anymore.
My lady, where people are enforced and locked up, I just feel that it does make circumstances more difficult for them, but it shouldn't be considered a problem.
What would be more difficult for them if they're locked up in terms of condoms?
My lady, I don't think we understand the circumstances. We will have a witness, obviously, to testify it or concerning the overcrowdedness in prisons. But I don't think people actually dispute or deny the fact that sexual intercourse is a daily occurrence within the prison. The problem is there are very little privacy, so people are exposed to that. If values and norms are no longer a problem, then I presume it shouldn't be looked at in a different way, and then we can perceive it in a positive manner. Other than that, I can't say anymore, my lady. If we have to see it, it is a fact, it is available. If we can look at it in a positive manner, then we can appreciate it in that fact.
You see, madam, in that answer I picked up the bias. Values and norms of whom? Your values and norms.
No, not at all, my lady. When people are being exposed to that without a choice. I'm not being exposed to that, my lady. I've never been exposed to that.
Madam, I've put here what I wanted to. There's only one other aspect. Madam, I'm putting to you that your report is not informed by any fact as far as the condition of prison is concerned that the court should rely on, that you are biased against any form of imprisonment. Do you want to? There's one other aspect, thank you. Madam, do you know, have you followed the Devani case?
No, my lady.
No, not now, when it's in court. The whole process, remember?
No, my lady.
Okay, let me put to you. Mr. Devani left the country and found himself in England. Do you know that?
No, my lady, I honestly did not follow it.
No, then I'm going to put to you that in an English court, the Department of Correctional Services, and in the person of Mr. Smallberger sitting next to me, filed affidavits and convinced the English courts that our prisons are according to international standards, so much so that they agreed to the extradition of Mr. Devani. But you're saying our prisons are just terrible.
My lady, I can just say that the prisons are overpopulated at this point in time, and that was according to the latest report, 2011-2012, the annual report. I'm not an expert. I was informed that the expert will testify what I've seen, what I've been exposed to, and what the clients virtually expressed to us. We cannot say that it is a perfect world out there. So if other factors will be placed before the Honourable Court, it is in the hands of the Honourable Court.
And Madam, put to you lastly that you don't call it a recommendation, you call it an opinion that the court should consider a community-based sentence, and in the way described to you, it is shockingly inappropriate to even suggest that a community-based sentence in this matter is appropriate.
I take note thereof, my lady. I'm entitled to my opinion.
As a court, please. I have nothing further.
Yes, Mr. Roo?
Just maybe one question that I don't know if you can answer. Do you know if Mr. Devani was detained in jail here or in a different facility?
I honestly wouldn't know, my lady.
I have no further re-examination.
Mrs. Verheer, just turn to page 19.
Yes,
Of-
my lady.
Yes. Of Exhibit EEE. Point number 2, you say his detention ensured aversion. I'm not quite sure whether I understand this.
It was when he was detained just after the incident, before bail was granted, my lady.
Yes, what about that?
It was just a severe eye-opener to him. He was not detained in the prison. He was detained in the police cells, if I understood it correctly.
Yes, so what are you saying about that?
Sorry, my lady.
I understand what you're saying now, but what are you saying about that?
That it was really a shock and an eye-opener to him, my lady.
Yes. Where did you get that?
I'm
Is
sorry,
that
my-
what he told you?
Yes, my lady.
That's what he said to you?
Yes, my lady.
Yes. Thank you. Is there any
Nothing, thank you.
any
my lady.
question arising?
Nothing there.
Nothing. Thank you very much, Mrs. Verheer.
Thank you, my lady.
You may
Ma.
be excused.
Thank you, my lady.
Yes, Mr. Roux?
My lady, on the understanding that Mr. Nell will call the person from Correctional Services, we'll await that. There are no further witnesses to be called, but what came to my attention that I believe it's relevant to the proceedings was a press statement issued on behalf of the parents. And why I believe it's relevant, because the payment issue was raised, and I think that the correct position should be put before the court in terms of the press statement and also from the legal perspective, what it was really all about.
Yes, this press statement came out when?
It's a press statement. It's issued by Advocate De Bruin, SC, and the attorney on behalf of the parents.
Yes.
I will just ask, I see Mr. De Bruin's court, I don't have copies. I believe copies, otherwise I will make copies available to the court as an exhibit, but I think it's important to read that into the record.
Yes, I'd rather we have copies before you start reading.
If the court would just bear with me.
Yes.
It would be exhibit double F, my lady.
Mr. Nell, you've got the statement? You've got the press statement?
Yes, I do.
Thank you, my lady. I would then read it into the record, and I will also make short submissions from our perspective. It says, press statement on behalf of Mr. and Mrs. Steenkamp, the parents. 1. Certain disclosures in court yesterday have made it necessary to issue the statement. 2. We have advised the parents to remain neutral in regard to sentence, in a sense that they should not be seen to attempt to influence the sentence in any way. 3. After Ms. Steenkamp, in brackets, the deceased, was killed on 13 February 2013, the parents were in financial difficulties. 3.1. This was mentioned to Mr. Pistorius' lawyers during discussions in regard to a possible civil claim by the parents. 3.2. We were contacted soon afterwards by Mr. Pistorius' lawyers with an offer that Mr. Pistorius would contribute an amount of 6,000 rand per month towards the parents' rental and living expenses. 3.3. Payment took place from March 2013 until September 2014. 3.4. When the offer was made during March 2013, we, on behalf of the parents, thought that it would only be fair to Mr. Pistorius that the public should know this. The request of Mr. Pistorius, conveyed through his lawyers, however, was that the matter be kept confidential. We have honoured this request. 3.5. We were therefore quite surprised yesterday when this fact was disclosed in court without any prior warning to us. The fact that the matter had been kept confidential at the request of Mr. Pistorius' legal advisors has also not been placed on record. 3.6. The parents intend to repay this amount to Mr. Pistorius as soon as arrangements can be made in that regard. 3.7. It was always the intention of the parents that the amount of 6,000 would be set off against any claim that they were going to institute. However, once they had decided not to proceed with the civil claim, which decision was only taken during the past few weeks, it follows that the money will be repaid. That's on the first part. My lady, submissions will be made later that the money were paid over unconditionally, and it's still the instruction that he doesn't want it back. It's for the parents to decide, but there was no condition attached to it. 4, the settlement offer. In view of the pending civil action, we considered it appropriate to attempt some kind of settlement in that regard as soon as possible. 4.2, this was considered especially because the parents were emotionally suffering quite badly, and an early settlement was considered to be appropriate in order for them to get some closure on this specific issue as soon as possible and to avoid a lengthy civil case. 4.3, it was for this reason that we, that's now the legal advisors, representatives on behalf of the parents, approached Mr. Pistorius' legal advisors with a request as to whether the matter could not be settled. At that stage, the parents were not aware of our approaches, and discussions between the legal teams were confidential. 4.4, the offer of settlement was then made by Mr. Pistorius. 4.5, when the parents were made aware of this offer, they considered it carefully, but decided for various reasons that they did not want any payment from Mr. Pistorius. This is also why we were instructed to advise that no civil claim would be instituted. 4.6, we placed this on record to make it clear that the request for an offer emanated from our side and not from Mr. Pistorius' side. He was responding to our request as to whether the civil claim could not be settled. 4.7, we agreed with Mr. Pistorius' legal advisors that this issue could be raised by them, but then in a context that it had been rejected. My lady, the only part of what submissions will follow is that when we were told that they did not want the money, there was a further offer to say he sold his car in the last amount, proceeds that he had at the time. The proceeds for the car was $375,000. There was contact with the legal advisor to say, we understand that you don't want the money. We're going to pay it into your trust account. Please give us the trust account for the parents to consider, should they at the later stage reconsider. The trust account number was given, but subsequent to that, before the payment could be made, we were informed that they've made up their minds. They do not want the money, and for that reason only, the money was not paid over. That's the full history of the money. Witnesses will be called, and the argument will obviously follow after the state witnesses. Thank you.
Thank you, Mr. Roux.
Yes, Mr. Court, I intend indeed to call witnesses. I do, however, need time just to consult with the witnesses again before I call them.
Mm-hmm.
I see it's 12 o'clock, and but I would need at least 45 minutes to go through evidence.
5 minutes.
Yeah. That makes it difficult because we run into lunchtime. So if I could perhaps ask people to be back at, say, I would have wanted to start at 1, my lady, if I could talk to court personnel, and then we could sit to 3 if I take the hour lunch now. But, my lady, I'm in the hands of the court. I would need time to consult with this witness.
Yes, how much time?
I would need an hour, my lady, to be...
1 hour?
Yeah.
Okay. And you said 4 witnesses. Did I hear you correctly? 4 witnesses?
No, my lady, at most 3.
3.
My lady, as I'm standing here...
I'm not trying to influence your decision.
As I'm standing here, I'm thinking 3 or 4, my lady, yes. Sorry, I've now... but they won't be long, my lady. I'm sure that we'll manage to finish it.
I'm not taking you at your word for that.
My lady, I can't guarantee it at all.
It's more like it.
Yes.
Let me just find out, would it suit everybody if we came back at 1 o'clock?
Can we make it 1:30, my lady? If people would want... My lady, I'm going to consult and get everything ready. If we make it 1:30.
Well, make up your mind. You need an
I've made
hour.
up my mind. Can I have 1:30, my lady?
Pardon?
Can I have 1:30?
You need 1.5 hours.
Yes, ma'am.
All right. We'll be back at 1:30.
As a good.
Carry on,